Hi, my name is Scott Green, and I'm the managing partner of the Green Law Group in Simi Valley, California. And this is the third in our series for the Master Contractor webinar series. And our goal for this series is to help contractors avoid legal pitfalls. And so hopefully we'll be able to do that, and you'll all get something of value out of this. The Green Law Group is about 15 or so folks, 6 or 7 lawyers, staff people, paralegals, and we're literally built for the construction industry. So this is what we do. I've been doing this since 1978, and before that worked as a contractor, working my way through law school. So today's webinar is going to focus on contracts. But before we get there, I just want to give a shout out to our sponsors. These are all folks that should be in your network. If you're in, particularly if you're in Ventura County, where we are. But let's start with Easy Law construction notices. And full disclosure, I formed Easy Law in 1985 to help contractors secure and collect what they earn. So Easy Law has been around for a while, and they have hundreds of clients throughout Southern California. And Easy Law does preliminary notices, mechanics liens, stop payment notices, bond claims, and the like. And if you're not familiar with them, please check them out. They can be incredibly critical to your ability to collect your money. Ventura County Credit Union, great folks over there. You're more than just a number at the Ventura County Credit Union. Relationships make a difference there. I can attest to that myself. They're my lenders. The Blue Book, they've been around for a long time. Bill Gribble over at the Blue Book will hook you up and help you network and grow your business. Builder's Bookstore in Canoga Park. If it's in print and if it's about construction, they have it. Check them out on their website, an incredible website. And then the Ventura County Contractors Association, great group of folks. You can network and go play some golf every once in a while. They have fishing trips. But it's great to be a member of an organization with other folks doing what you do. So I highly recommend you check them out. Say hi to Daylene. If you call over there, let her know I told you to check them out. So I think, success is built on knowledge. The more you know, the better. So that's what we're about in today's presentation. And then this, I have to give you this fair warning. I'm going to give you a bunch of general information for your specific legal matter. You want to talk to me or another experienced construction lawyer, because your specific facts may change the outcome of something you hear today. So the law is filled with general rules and exceptions to the general rules, and things change rapidly based on new statutes, new cases. So, you need to drill down and get a specific recommendation based on your facts. Okay, a little info about Green Law Group. There's bios here about our lawyers. And let's get into contracts. Okay. So, nobody goes into the construction business because they love paperwork. And believe it or not, I don't like paperwork. But when you've got a dispute with somebody, the paperwork becomes extremely important. So when somebody contacts me and they say, hey, Scott, I'm owed X amount of money, I almost always will say, all right, send me a copy of your contract. Send me the recent correspondence you've had regarding the dispute. Let me see your last invoice. And let me know if you did a preliminary notice. Send me the proof, if you did, of mailing and delivery. Send me your releases. And so I'm starting out, and I've got to look at all the paperwork. And I start with the contract. So, when somebody is reaching out to me and they say, "Oh man, I don't have a contract because I've done business with this person for a really long time, and it's a handshake deal." Well, you still have a contract. That's an oral contract. But the question is, what are the terms and conditions of that agreement? And when there's a dispute based upon an oral agreement, the parties are never going to agree. At least, if you're owed money, the other side isn't going to agree with your recollection of what that agreement is. So you have to get it in writing. That's the first rule of contracts. Have a written contract. And in some areas of construction contracting, the law requires a written contract. If you're doing home improvement work, you must have a written contract. We'll get into the details of home improvement contracts a little later. If you're doing a home improvement pool project, you must have a written contract. Well, it's true in other areas, commercial areas, etc. The law doesn't mandate a written contract, but it's really foolish to not to have an agreement. So then, what is a contract all about? What does it do for you? At its essence, a contract is about shifting the risk for liability and responsibilities between the parties to the contract, shifting the risk. So when you understand that and you get a contract that somebody else drafted for you to sign, you want to be thinking as you read through it, and you must carefully read the entire contract before signing it. Every provision you read in the contract, you want to ask yourself, well, what risk is being shifted to me? So, for instance, the obvious things, if you're the contractor and you're going to perform, the risk of performing is being shifted to you. Well, that's okay. That's what it's all about. The risk of taking a loss if you can't get the work done within a profitable basis based on your price, that's a risk that's easy to understand. But what about the risks of incurring attorney's fees if there's a dispute? That's of course near and dear to my heart because it's something that I look at. If, for instance, somebody contacts me and they say, "Hey Scott, I'm owed $250,000." It's like, okay, and I look at the contract and everything, and then we're talking about it. And let's say my kind of general assessment is that the client's got a really good case for his 250. They performed, they were no offsetting claims, delays are not a problem, unsigned change order is not a problem, got a really solid case, 250 grand. But the other side has got deep pockets and they've got their heels dug in. They don't want to pay. So we're going to end up going to court, which means the filing of a lawsuit, which means money is going to be spent on legal fees. And so I'm often asked, well, Scott, how much might that be? Well, I can never say for sure at the outset how much the fees are going to be because I don't know what the other side is going to do. I don't know if they're going to want to take a deposition or 15 depositions. I don't know if they're going to be asking for, all of your documents. I don't know if they're going to send, a lot of written discovery that's going to require, a lot of attorney time. I don't know if they're going to be filing motions, which are request to the court to take some specific action in regards to the case. I don't know if the case is going to go on for 6 weeks, 6 months, or a couple of years. I don't know the answer to any of those questions. So when somebody asks, well, how much is this likely to cost? I can only talk in real general terms. I might be able to give you some idea about maybe the next 30 to 60 days. The things that I can see and forecast, like how much will it cost to draft a response to a lawsuit or your complaint, things that are within our control, we can estimate that. But there's so much that is not in our control because we are only, in charge of one side of the dispute. So, but generally speaking, I can tell you that if your case goes all the way to trial, and it's a jury trial, which some of them are, you're probably looking at $250,000 or in that range. I mean, it's going to be a big chunk of money. So in your contract, if you don't have a provision in your contract that provides for the recovery of attorney's fees, then, even though you may come in, you've got a really strong case for $250,000, you've got to now take into consideration the fact that everything you spend on lawyers is going to be a net reduction in anything you might recover. So that's a significant risk. So whenever I'm reviewing a contract for a client, I want to make sure there's an attorney fee provision in the contract. Because if you don't have that provision in the contract, and by the way, the most likely dispute you're gonna encounter is you're gonna work and you're not gonna be paid. It's probably I don't know, maybe 8 to 9 people out of 10 who contract my office. It's about having performed work and not being paid. So if you've got to go chase after somebody in court when you haven't been paid and you win, well, you're going to want to get your attorney's fees back because they can really mount up. But you do not get those fees, generally speaking, unless you have a provision in your contract that provides for the recovery of attorney's fees, to the prevailing party, which means you got to win, which is important because if you don't win, if you sue and you have an attorney fee provision, you pay the other side's fees. So, important to not jump into litigation where you don't feel like you have a really solid case, which brings me to another important point. I can never give you, and no attorney can ever give you a guaranteed dispute. So, it's always going to be, possible that things will end up going in a different direction that even I imagine they might from the outset, because it's been true in my 40 plus years of being involved as a trial lawyer that I continue to learn things about my cases all the way through trial. And sometimes those are things that are not favorable to my client. So cannot give a guarantee. Okay, so risky bet. When you go litigate, but that litigation is going to be based on the contract. We've had several disputes of late where we're representing contractors who have been sued by property owners who didn't read the contract on their side. And fortunately for our clients, we had them into good contract documents, which essentially required the owner to give specific written notice to our clients of any disputes before taking adverse action against our clients. And like I said, we've had this run of cases of late where the owners jumped the gun and they didn't do that. They terminated or they backcharged or they breached the contract without, giving our clients written notice of whatever their complaints were. and giving our clients a reasonable opportunity to respond. So what do we do with that when we get into court? We bang the owners over the head with the fact that they didn't follow the contract. So it isn't just one side that needs to read and understand the document. Anybody signing a contract needs to read it carefully. So when I get a contract and somebody has asked me, hey, Scott, will you review it? I'm looking for what I call deal killers. And the example I give of a deal killer provision is a provision that says something along the lines of, listen, in the event of a dispute, the contractor has to continue performing. It's not an uncommon provision, and the courts do enforce that. What you need to think about is what that might mean for you. What if the dispute is you haven't been paid and it's a big chunk of money and you want to stop working because you haven't been paid, but you've got this contract that says you can't, you need to continue to perform. That's a deal killer. They're out there, you got to look for it. So when you're reading contracts, go through it, circle the provisions that you have questions about, consider going back to the party that gave you the contract and asking them specific questions about the provisions you have questions about. And then if you still aren't certain about the meaning of a provision, then shoot that over to your lawyer and have the lawyer focus their attention on the provisions that you don't understand. When somebody just shoots me over a contract and says, hey, Scott, will you read this? It's like, okay, sure. But what am I looking for? What should I focus on? Better if you give me an idea of what questions you have. So this PowerPoint, by the way, we're gonna move through some of these slides fairly quickly. I'm not following it exactly. I think that'd be a little too boring. You can read this on your own as you go forward. So there's some basic information about contracts, the elements of a good contract. Take a look at this. There are a lot of form contracts out there. So, you don't have to have an attorney draft a custom agreement for you every time. I mentioned the Builder's Bookstore before. There's their website. They sell contract forms. The American Institute of Architects sells contract forms. AGC, Associated General Contractors, so on and so forth. The AIA document, drafted by architects, guess who benefits in the risk shifting in that document? It would be architects, right? With the Associated General Contractors, guess who is shifting the risk a little to their benefit? That's right, general contractors. Construction Owner Association of America, that's kind of a neutral document. And I think one that I should have on here, I don't think I do, is consensus docs. The consensus doc is been around for about 10 years now. That's a contract template in the construction industry where there were contributions to the drafting of it by all stakeholders in construction. So it's a fairly well-balanced agreement, which isn't heavily favoring one party over the other. So check them out. I like their document forms. The other thing to know about a template document that you might buy is they can be edited, probably should be edited to fit your particular situation. And so you can, down at the bottom, custom drafted contracts, you might contact us and say, well, I've gone an AGC template and I've gone through it. Can we make some edits to that? Absolutely. Because the other thing about contracts is one size doesn't fit all. I mean, you need a different kind of contract for a home remodeling project versus you're a subcontractor on a public works job, or if you're doing a commercial build from ground up as opposed to digging a pool. So, the contract should fit the project. That's important to know, important to realize. All right. So some common provisions. Um, Pay if paid and pay when paid. These are important to understand. Pay if paid has actually been voided by the California Supreme Court, although you'll still see them, every once in a while in a contract. Pay if paid is a provision that says you're not going to get paid unless, let's say the general contractor is paid, the subcontractors don't get paid. If you see that one, it's not enforceable, but you probably ought to, have a conversation about it as to why that's in the contract. Pay when paid is enforceable. What that means is, the GC is going to say, look, I'm going to pay you when I get paid. And, that may be 30 days, 60 days, 90 days. It's what is typical or what the parties really expect to happen. In other words, it's a little squishy, but it reflects, the reality in the construction business because, being pushed out 30, 60, 90 days, even longer, is not all that unusual in construction. So you should have this conversation with the party you're contracting with to find out, how that's going to impact your cash flow. So read this information to get a chance. And there's some more on that. No damage for delay, time extensions. These are also risk shifting provisions. So for instance, if you're on a job and there's a schedule, and the whole thing is supposed to be done, let's say in 6 months, and there are delays that have nothing to do with you, now it's a year or a year and a half instead of 6 months. If there's a provision in that contract that says you get no damages for delay, at most what you get is a time extension to complete, well, that can hit your pocketbook pretty hard. So it's another example of risk being shifted, and something you need to be aware of and look out for. Here's that language about continuing to work in the face of a dispute, the deal killer. There's the attorney fee, a little bit more about that. Change orders, even if your contract doesn't say they should be in writing and signed before you perform, you need to do that as a standard practice. And also with change orders, don't forget to include the effect on the schedule. I see this all the time. You sign a big change, you put the amount of money in there, and now it's going to take you an extra 3 months, and you didn't say anything about that in your change order. You're stuck with the schedule that, to still get it done. So take a look at that and read through this information. Oh, these are the termination for convenience or termination for cause. Very common now to see termination for convenience provisions. Read it, look for it in your contract, understand what that means. Termination for cause means somebody's going to write you up and say, look, I'm going to fire you because you didn't do X. And then if you don't correct X, you're going to get terminated. That's termination for cause. Termination for convenience is, hey, the bank just pulled the loan. Sorry about that. I need to shut it down. And when a project is terminated for convenience, you want to make sure that you're going to at least get paid for all of your costs. You may not get paid for your lost profits. It's going to depend on the language in that provision. Okay, incorporated documents. A lot of contracts refer to other documents that are incorporated into your contract and then become part of your contract. So for instance, if you're a subcontractor and you're looking at the contract you got from the GC or the prime or the direct, all those terms now refer to the same, it used to be just called the general contractor. So you're looking at the contract and it says your agreement incorporates the agreement between the prime contractor and the owner. Well, you need to have a copy of that because it's now part of your contract. And so if you just gloss over that, don't get a copy of it and don't read it, and later there's a dispute, maybe there's a liquidated damage provision in that owner prime agreement that just passed down to you as a sub. And who knows, maybe it's $1,000 or $5,000 a day for delay damages. And you just signed off on that, not even realizing it's there. So when you see a provision of the contract incorporating other documents into your agreement, well, then you need to get those documents and you need to read them because they're part of your deal. All right. So I don't have time to go through all of these sample terms and conditions, but these are just samples. So, you might read something and go, oh, maybe I should have that in my contract, or maybe I don't want to have it in my contract. But to be successful in the construction business, you need to get yourself very well educated on contract language, terms, what you want in your agreement to try to minimize your risk. So here are some examples here. You can arbitration. I get asked about this a lot. I recommend arbitration provisions because the courts are too congested. Things get rescheduled too often. It's going to be a lot more expensive for you to go through litigation as opposed to arbitrating your dispute. Arbitration means you're going to have a private party, usually a retired judge or a senior attorney who's going to make the decision in the case. And the scheduling is going to be much more predictable. And it's not going to take as long as it would in litigation. So good thing to have that. There's the attorney fee provision. So check those out. Here's just a list of common allegations for breach of contract, what somebody might accuse you of doing, or what you might accuse somebody of doing. If you're not paid in accordance with the terms of your contract, then the party who is obligated to pay you and isn't, they're materially breaching your contract. Now, what does that mean? Should you just stop work and walk off the job? No. Contact me, let's talk about it. Because when you think your contract has been breached by the other side, if you quit working and you end up in court at some point, and let's say the owner didn't pay you and they were actually justified, and you didn't understand that at the time, when you walk off, you're exposing yourself to the risk that you're violating the contract, and whoever the owner hires to come in behind you and finish your work, and of course charges a lot more than you would charge, that those damages are going to flow to you, plus attorney's fees and everything else. So do not walk off a project before it's completed without talking to a lawyer. That's critically important. All right. Yeah, and here you go. I put it in writing for you. Walking off a job in a payment dispute may get you sued. So there you go. All right, so be proactive, avoid disputes. What I'm saying here is don't do things that, make it look like you're an easy mark. So for instance, if you get a contract that's the size of a small phone book, and you just turn that puppy around, sign it, send it right back, and obviously you didn't take time to read it, what's that saying about you to the other side? Might be saying that, you're not really paying attention. And what if you don't do a preliminary notice when you should? What's that say about you? Might mean that you're, a little bit of an easy mark if somebody wants to pick on somebody, if money runs short. I've got a note here about project management software. I've been harping about the use of project management software for years. And now that we're in the midst of this COVID situation, I think it's even more important that you can communicate with your employees and your customers via the web for things like scheduling, change orders, weather delays, keeping track of important meeting minutes. So check out the project management software. All right, also being proactive, get change orders signed, etc. And be great when it comes to customer service. I mean, sometimes, if you make a mistake, you need to take responsibility for that and not try to push the cost on your client. That's hardly ever going to work out. And we all make mistakes. I've learned, as both a contractor and a lawyer, when you take responsibility and you own it and you fix it and you pay for your own mistake, that's great marketing going forward. And folks are going to say, hey, look, you can trust these folks. They own it when they don't get it right. That's your reputation. So be proactive about maintaining your reputation. All right, home improvement contracts. I threatened to get into this a little bit. Home improvements, that's the most highly regulated segment of the construction business. If your contract for home improvements isn't at least 10 pages long, you're not using the right contract document because the law requires a number of provisions to be in it, and it's got to be at least 10, 12 pages. If you're listening to this webinar, you're entitled to a free home improvement contract and I think 3 other contract templates that my office will send you gratis. So send me an email if you don't have an HIC contract. We'll send you some information on that. But you got to have it right. And here's sample provisions. You can scroll through this. A lot of these provisions are actually required. Hey, pool contractors, you guys are really in trouble if you don't have a written contract. Read the last sentence there. It says, shall be void and unenforceable by the contractors, contrary to public policy, if you don't have a written contract that complies with the law. So don't mess with that. And if you haven't had a lawyer put eyeballs on your contract, you probably should do that. There's more, scary things about pool contracts. By the way, pool contractors, most highly litigated contract in the state, I believe. For one reason or another, pools end up being very, pool construction leads to more disputes. The reason for that, not really sure. Your guess is as good as mine. But you need to tread carefully as a pool contractor. Warranties. Everything has got a 1-year warranty. So take that for granted. You should spell that out in your contract. You might as well get the marketing advantage of it. And then the 4-year warranty is based on the fact that you can be sued for breach of contract for up to 4 years. So if somebody says, hey, they discover 2 years out that, let's say you said you were putting in a certain type of water heater and you put in something completely different, and you didn't comply with your contract, you can be sued. 4 years on a written contract. The 10-year warranty language is really for things that are hidden and undisclosed. So if you put in a structural member, for instance, and then the building collapses, and it turns out that you undersized that structural member or didn't put in the right hardware, you're exposed for 10 years at least, maybe even longer. Okay, more information there about warranties. Good to know. You need to read all this stuff. Okay, we're flipping through here. Contractors license bond. You all get a license bond to maintain an active contract. Here's some info about claims against a license bond. And then here's a 10-day stop work order. This is kind of rare. This is used when and there's a dispute between a general contractor and an owner, and the general contractor wants to avoid getting sued by their subcontractors because they need to stop the job. There's a whole scheme here for posting notices, etc. It's handy. If you're a GC, you should know about this. I've only used it a few times, so it doesn't come up very often, but read through this. Prompt pay laws. Love prompt pay laws. God, it used to be that before prompt payment laws, let's say you're a sub and you're owed 150 grand and you're all done. And you go to the GC and you want your 150, and the GC says, well, I think, there's some ticky-tack stuff, punch list stuff. Maybe it's $3,000-4,000 worth of stuff. I want you to do that work before you get your 150. That used before prompt payment laws, that was standard. So if you were a sub, you could be leveraged into doing work just because you were desperate to get that last big payment. Now the GCs and property owners are limited. They can only hold 150% of the amount in dispute. And if they hold more than that, then you can turn that around on them and make a claim for a violation of this prompt payment law, which then can give you 2% per month if you can prove that the money was withheld without justification. So it's a handy thing. Keep that in mind. Okay, bankruptcy basics for contractors. You may find yourself on the wrong end of a bankruptcy notice where you performed work and then your customer can't pay you and is going bankrupt. Best thing I can tell you there is get in touch with us right away, because there are some very short fuse notice requirements to protect your rights and perfect your ability to record a lien, for instance, so that you can be a secured creditor in bankruptcy. So BK, get a BK notice, talk to a lawyer. I'm not going to try to go through all the bankruptcy implications here. We don't have time for that, but read through this written information at your leisure. Like I said, the most important thing, if you're owed money, is to try to secure your claim in bankruptcy with a lien. But you got to be real careful about the timing of that and do it with the assistance of a lawyer. Okay, and here's this general information on that. On the potential plus side, if you're subject to a judgment you can't pay, that could result in your loss of your contractor's license. Bankruptcy may be a way for you to address that issue so you can maintain your license. Chat with me if that's your situation. Chapter 11 is about reorganizing a business. There's a lot of that going on now, unfortunately. If you get notice that one of your customers is in Chapter 11, to contact my firm or another lawyer and find out how that's going to affect you. If you're the one considering an 11, they're very expensive, and my firm doesn't do 11s as a representing debtors. So you want to find a bankruptcy lawyer for that. Okay, there's a little promo for Green Law Group, and we just went a few minutes over our 30-minute goal. Covered a lot of information. You have questions though, there's my email. Email me as opposed to phoning me, because I hate to play phone tag. And make it a good day and make some money out there. And we'll catch you next time. We're going to, I think our next webinar is dealing with employment issues, which is a big, heady topic. So take it easy. We'll see you next time.